Hello there and thanks for joining us in Project Justice this week. I remain your host, Utuba Omoran. Our focus this week is on the government anti-corruption war, with specific reference to the recent recall of some judges who were asked to step aside based on investigations on corruption allegations against them. The campaign began with a lot of gusto when the Buhari government assumed office. Critics, however, have said that there's so much dust has been raised with no substance at the end of the day. While others have criticized the style of the anti-corruption war, describing it as selective and a mere media frenzy. But the government has been undeterred, dismissing the claims as simply corruption fighting back. However, while there have been reports of massive loot discoveries, the statistics hasn't been that flattering for the government's prosecution of high-profile cases, especially of politically exposed persons. Recent losses at the courts, including that involving Justice Adeni Ademola of the Federal High Court, have been a major setback. Others are also yet to be charged to court months after arrest. The development resulted in the chairman of the Presidential Advisory Committee on Corruption, Professor Issei Sage, Senior Advocate of Nigeria, accusing the judiciary of, quote, not being on board in the government anti-corruption drive. Well, that comment provoked an immediate reaction from the head of the Nigerian judiciary, Justice Walter Onogen, who accused the executive of failing to act on cases of judicial officers who have been found wanting by the National Judicial Council, NJC, and recommended to the president and some governors for dismissal. So, is the judiciary and the executive, the presidency in particular, daggers drawn yet again? My guest today in the first of these two-part interview is a special advisor to the president on corruption matters, Barrister Okoy Obonabla.
Let me say one thing before I go into the details. Look, fighting corruption is not all about sending people to prison. The essence of the criminal law system or institution is to reform people, to serve as a deterrence. You know, so it is not about conviction. It is against the principles of good prosecution for even the prosecutor to want to convict or secure a conviction at all costs. It is unprofessional for a prosecutor to do that.
Well, the full interview comes up in a moment after this news break.
The National Judicial Council says its decision to recall judges earlier directed to excuse themselves from judicial duties pending the conclusion of investigation is not hasty, as there is no proper appeal before the Court of Appeal against the affected judges. The Council faults the press statement issued by the Special Assistant to the President on Prosecution, Okoye Obonabla, on notice of appeal filed on 7th of April and 6th of June for discharging and acquitting Justice Adeni Ademola and two others. The Council explained that the parties were invited by the FCTI Court for settlement of records to be transmitted to the Court of Appeal on 18th and 21st of April, and the appellant failed to turn up until it expired on 7th May, when it exceeds the 45 days allowed in law for compilation. The Supreme Court has validated the provisions of Section 306 of the Administration of Criminal Justice Act 2015 and Section 40 of the Economic and Financial Crimes Commission Act 2004, which prohibits courts from granting stay of proceedings in an ongoing criminal trial. In the appeal filed by the former People's Democratic Party (PDP) spokesman Olisamitu, a five-man panel of justices led by Justice Datijo Mohammed unanimously held that the provisions of both laws were in agreement with Section 36, subsection 4 of the Constitution, which provided that any person charged with a criminal offense shall be entitled to fair hearing in public within a reasonable time. The Federal Capital Territory High Court has ruled that the Nigerian Bar Association presidential candidate Joe Gatzama, who lost at the last NBA presidential election, has the right to approach the court to hear his grievances. Justice Adeniyi Ademola in his ruling held that the NBA constitution, which stated that an aggrieved candidate must first explore the committee set up by the NBA before approaching a court, is an attempt to impede on his rights as enshrined in Section 36 of the Constitution.
And now to our featured interview for the week. I told you earlier my guest is a special advisor to the President on prosecution, Barrister Okoy Ogbonobla. How's the anti-corruption war of the Buhari administration going so far?
I can score the administration 80%. As far as the war against corruption is concerned. This administration came into power on 3 anchors, or cornerstones: fighting corruption, fighting Boko Haram, and also revamping the economy. So, as far as the anti-corruption agenda of this government is concerned, we have done progressively well. You have been hearing the number, the money we have recovered from ghost workers alone. The salary wage bill of the federal government bureaucracy used to be about 160 billion naira per month. It has fallen down, if I can remember very well what the Minister of Finance said about 2 months ago. It has fallen to almost 110 or 111 billion naira. That is only for ghost workers. Then pension too. We used to have a lot of pension fraud. People who are not entitled to pension getting pension, and the wage bill was very, very high. And the executive secretary of the pension the transition directorate, Barrister Sharon Ikazo, the other day said almost 40 billion naira have been saved from pension fraud. That is a consequence of the war against corruption.
What of the aspect of prosecutions of corruption, which is the area where your specialty really lies? Yes. You are the special advisor to the President on prosecutions. Yes. How is that going?
Let me say one thing before I go into the details. Look, fighting corruption is not all about sending people to prison. The essence of the criminal law system or institution is to reform people, to serve as a deterrence. So it is not about conviction. It is against the principles of good prosecution for even the prosecutor to want to convict or secure a conviction at all costs. It is unprofessional for a prosecutor to do that. Latest statistics from EFCC for the first quarter of this year, about 62 convictions is unprecedented. I don't want to go to last year, but this year, the first quarter of this year, it's unprecedented, and it gives credit to the will of this government to enforce the law and ensure that those who cross the line are punished.
How many of those are high-profile cases, which a lot of Nigerians will want to see diligently prosecuted and convictions secured?
Well, I cannot differentiate, make a distinction between high-profile and less-profile cases. But I can tell you that some of the convictions are in respect of what we call politically exposed people. I am also the secretary of the Administration of Criminal Justice Act 2015. There's a committee known as Administration of Criminal Justice Monitoring Committee. It is established pursuant to Section 471 of the Administration of Criminal Justice Act.
What have you found to be one of the limitations, in spite of the fact that we have this very noble legislation in place that a lot of people believe would have helped fast-track the prosecution of criminal cases? Why are we still having problems?
Well, the attitude of defense counsel. Some of the lawyers do not want matters to go on. Some of the lawyers, especially those representing politically exposed people. And the politically exposed people have a lot of resources, so they take the best of the lawyers, and the lawyers try to stall matters from going on. And I will give you an example. Just on Friday last week, the Supreme Court gave a landmark decision concerning Section 306 of the Administrative Criminal Justice Act. That section says that there shouldn't be stay of proceedings in criminal matters. And the contention of the counsel to the former National Publicity Secretary of PDP, Odisa Metu, who went to the Supreme Court saying that the Supreme Court should set aside the judgment of the Court of Appeal, which dismissed his appeal. His appeal was that the trial court, presided over Judge Saban, refused to grant him a stay of proceedings. The Supreme Court said that, the stay of proceedings being part and parcel of the administration of criminal justice, the Supreme Court cannot do that. So the Supreme Court established the principle that in criminal cases, both in the High Court, in the Court of Appeal, and the Supreme Court, there should be no stay.
We seem to have had a consistency from the Supreme Court in that, because also in the case between Saraki and Federal Republic of Nigeria over his trial at the Code of Conduct Tribunal, the Court of Appeal as well as the Supreme Court has told that part as well.
No, in the case of Saraki, they did not make a categorical pronouncement because it was not one of the issues canvassed. It was just what we used to call in law obiter. On the passing, the Supreme Court made an order that they should stay proceedings in the case. But there was no categorical pronouncement on the legality or the constitutionality of Section 306. Before, because lawyers were arguing that, some of the senior lawyers were arguing that the Section 306 of the Administration of Criminal Justice is at variance with Section 36(4) of the Constitution of the Federal Republic of Nigeria. And you know the principle of what we call supremacy of the Constitution. If an act or an ordinary law conflicts with the Constitution will prevail.
We also had the same position from the Supreme Court in the case of Ojuzo Kalu, which had spanned several years on interlocutory appeals, over 7 years before it was reverted back by the order of the Supreme Court back to the trial court for continuation of trial.
That case was not specifically decided on the provisions of Section 36 of the Administrative Criminal Justice Act.
Section 306.
Yes, no, 306, yes. It was not on that.
The point I'm trying to make is the consistency of the Supreme Court, the appellate court actually, to ensure speedy and accelerated hearing of criminal trials,
and that is the
especially corruption-related cases.
That is the challenge we are having with some of the judges. And that is also partly responsible for the tension you see between the executive and the judicial branch of government. Some of the trial judges, not the appellate judges, they don't want to change, and apply the provisions of the Act. Like, for instance, the Act frowns at unnecessary adjournments, that you cannot be entitled to more than 4 adjournments. That if you ask for unnecessary adjournments, then you should pay a fine, and the fine should be paid by the lawyer. So that there should be day-to-day hearing. But some of the trial judges or courts, they don't really comply with that provision, that there should be day-to-day hearing of matters until judgment is delivered. Also, the Act frowns at interlocutory appeals. But despite that, some of the trial courts still allow interlocutory appeals. So and when those appeals come up, some lawyers will use that as an excuse to ask for stay. But as I mentioned to you, last Friday, the Supreme Court has stated the position of the law. So now, no lawyer will go to court and begin to ask for stay of proceedings, despite the provisions of Section 306, because there is a pronouncement by the Supreme Court. So we want the judges to cooperate, to partner with the executive branch of government, to ensure that cases are heard expeditiously. It is in the interest of their profession. Let me mention to you the example set by the Adamawa State High Court in the case of the former governor of Adamawa State. Yes, that matter, the trial commenced in September 2015. And by February 2017, a judgment was delivered. So I have to commend that judge who heard that matter. So I will urge other judges to emulate that example, good example set by the High Court judge who heard that case.
If judges and even superior courts and justices presiding on them have been very supportive on the anti-corruption war, how then do we place a statement accredited to the chairman of the Presidential Advisory Committee on Corruption, Professor Issa Sage, that the judiciary is not on board as far as the anti-corruption campaign is concerned?
I would agree with that statement in total.
But you have just said that the judiciary,
Yes,
especially the appellate courts, have been doing well.
It is not in all cases. I said we still have some judges who are still used to the old way of doing things, who do not want to attune themselves to the current trend or the reality. We have a lot of them. If you want me, I will give you an example. For instance, a lot of Nigerians have been shouting on that Dasuki is being detained. That case commenced in August 2015. As I'm talking to you, that case is still pending.
Whose fault is it?
The delaying tactics.
Employed by who?
The defense. Yes, because for instance,
Ms. Obla, I'm sure you are aware that the last two adjournments, Dasuki wasn't brought to court because the people holding him, the institution holding Dasuki, did not bring Dasuki to court, and that was why that case was adjourned twice.
I will not want to.
Which is the government?
Yeah, excuse me. Utibe, let us not run a commentary on that matter because that matter is still pending in court.
Pending.
Yes.
But it's just we touch on it because of what you said, that the defense and the court at the same time is. I'm looking at the responsibility of the prosecution as well.
Let me tell you. I just give you an example. Lisa Metu's case, where the
prosecution has been quite diligent.
I'll just give you an example. Let me give you an example. The delay tactics. You know, that matter was in the High Court, but now Justice Abang would have concluded that matter, but the matter was dragged to the Court of Appeal. And the judgment was against them in the Court of Appeal. They still went to the Supreme Court, and it was just last Friday that the Supreme Court delivered a judgment and ordered that the parties should appear before Justice Abang on the 19th of June 2017. So that is just an example. So if you look at the Act, the Administration of Criminal Justice Act, it says that all parties, all institutions involved in the administration of criminal justice should work together to ensure that cases are heard expeditiously. So the burden is not only on the prosecution. The burden is on lawyers, both prosecution and the defense. The burden is also on the courts. The burden is also on the law enforcement agencies. All these people are supposed to work together to ensure that there's seamless prosecution of criminal cases. So you cannot just pick out the prosecution. What is the duty of the prosecution? Present your case, file a case against whoever has run foul of the law. That is the duty of the prosecution. Then the duty of the judge is to ensure that the law is interpreted correctly, to take charge, because we used to say a judge is the master of the court. Take charge of the court to ensure that senior lawyers do not take advantage of the system to maneuver. They will not do that if a junior counsel is making such applications. They will never indulge you. They will even, rebuke you. But sometimes senior counsel come to court and take advantage if the judge is not firm. If he's not diligent, then punish the prosecution.
Has there been cases where the prosecution has not been very tidy
in
his job?
Instances like that where maybe the prosecutor is not diligent, you do not expect not to have things like that. Some people are not very diligent in the attitude to work and so forth and so on.
Ms. Obla, I hate to make reference to it because due to sub judice, but it's still one case that a lot of people have been expecting, because one of the high-profile cases which the government took on when it came in, especially when it set up the arms procurement investigation panel. The Dasuki matter is almost 2 years on the line. A lot of Nigerians feel that the federal government is really not prepared to prosecute that matter.
I told you we should not run commentary on that matter because the matter is pending. But from my personal experience, I've been attending court religiously since the commencement of that matter. My experience was that there was a spirited effort to stall the hearing of the matter. For whatever reason, I don't know, a lot of unnecessary applications were made. Even stay of proceedings was asked for in the court, and it was refused. They went to the Court of Appeal. despite the fact that the provisions of Section 306 is very clear, the provisions are very clear that there shall be no stay of proceedings. They still went to the Court of Appeal. And when they went to the Court of Appeal, they filed a motion there asking for stay. And then they brought back that motion and told the learned trial judge, we have filed a motion for stay of proceedings in the Court of Appeal. So you are duty bound to suspend proceedings. All the experience, what I saw, firsthand, it's not that I was told.
I also witnessed firsthand a situation where the defense pleaded for time or for them to have the opportunity to have access to the defendant so they can be able to prepare his defense properly. That told almost 6 months of the initial hearing of the case.
I can tell you that is a gimmickry employed by the defense. The defendant is not even in prison. He is kept in a guest house. He has access to papers and everything. So his defense counsel cannot pretend that he doesn't have access to his client. This is not true, but these are all the gimmicks we see.
Is it a free guest house where he's paying for?
I have told you that he is not in a normal detention facility.
But he's under detention.
Well, it's not our making. It's not our making.
Who is holding him?
The defense.
Who is holding
defense?
The defense.
Yes, you remember they brought a motion. They brought a motion before Judge Ademola saying that the federal government was in contempt of a court order asking the federal government to release the defendant.
I was also in court, Mr. Obla. I covered the proceedings. My understanding of what the ruling was that based on the bail that was granted by the honorable judge, that there was no flouting of the order of the bail because he was granted bail, and that the federal government holding him on something, perhaps is holding him on something else, and not necessarily on the bail which was granted by the court and which he met the conditions as prescribed by the court and was released from prison in December 2015.
I was trying to explain to you that he was first arraigned on possession of firearms, illegal possession of firearms.
And he was granted bail. As
he was granted bail. But the security people, they are very professionals, very professional. But as soon as he perfected his bail condition, they arrested him again, which is normal. Yes, and then charged him for money laundering. And because of that, he has refused to bring application for his bail. He's still insisting that the first bail that was given to him is valid. And I have told you the ruling on that point by the court. The court overruled him.
No, sir. I think he was actually granted bail on the money laundering. He was arraigned before the justices of the FCC.
Well, I'm not aware of that.
He was granted bail.
I am not aware of that.
He was granted and he perfected the conditions as of December 2015.
I am not
and
aware.
He was picked up, and the explanation we are hearing was that he is still being investigated.
Yes.
And 16 months after, he's still being investigated
and
not being charged to court.
Let me say one thing. In Nigeria, when high-profile people are charged to court, there is somebody who always wants to trigger a controversy somewhere. Why are you people not bothered about the poor people? The poor people are charged to court, some for over 10,000 naira, 20,000 naira, and they linger in prison for so many years and nobody is bothered. We shouldn't have two standards.
Maybe because people feel that if it could happen to a big man, then a small man really doesn't have any chance.
Where? Look, every country has its national interest. Even America. Let me give you an example. Because we shout about these human rights, we shout about rule of law. What of America that is a bastion of constitutional democracy? Let me tell you, maybe if you have not heard, the judgment of the American Supreme Court, when some people went to court to challenge the arraignment of terrorists that were captured in Afghan and taken to Guantanamo Bay and detained there. And the argument was that, why do you arraign civilians, before military tribunals? And the Supreme Court, the matter went to the American Supreme Court. Americans said no, because the national security of America is involved. So they cannot decide the matter based on, the rules of civil liberty.
But that is a terrorism case. But this is a money laundering case.
No. What position was he holding? He was National Security Advisor. Do you know how many people died in the Northeast?
Is he classified as a state as a terrorist?
Listen, so that we don't,
yes.
you know. Yes.
Oh,
yeah, but he was in custody. 15 billion US dollars was given to him to prosecute the war in the Northeast. At the end of the day, more than 30,000 Nigerians lost their life. More than 25 local government areas were captured by the terrorists. More than 10 million Nigerians were rendered homeless. Understand? And you think that we should not ask questions about what he did with the $15 billion?
Absolutely, the government has a right to ask questions. But my question is,
national security.
But my question is, if it has to do with national security and is that serious, why is he not charged for terrorism? So you have a real basis to hold him down. Why is he charged for money laundering? Because we've seen people who have been charged with terrorism cases. Some of them have been granted. Some of them have even been let free by the government.
I'm not aware. I'm not aware.
The government recently released certain...
After investigation. I mean, how long were they detained?
There were those who were
released. I understand one was there for 2. I understand one was in custody for 2 years. Why not? So he has questions to answer bordering on breach of national security.
The second part of that interview will come up next week. But here's what to expect.
Yes. Okay, for Justice Ademola.
Yes.
The decision by NJC is outrageous, scandalous.
The NJC seem not to be very happy with you. The NJC.
Why would they be happy? I'm doing my work.
The NJC says.
I'm doing my work.
The NJC says that its decision to recall the judges was based on principles of rule of law
and
fairness.
Which principles are we talking about? A judge who was arraigned, docked, and tried. That alone calls into question his credibility.
Well, that's a wrap for Project Justice for this week. Remember to follow us on the various social media platforms. I am Utuba Omoran, and I'll see you next week.